And today, the Supreme Court has answered that question by a vote of 6-3.
The U.S. Supreme Court has just issued a major ruling.
Major Second Amendment case.
Major Supreme Court ruling.
So, we need to talk about a recent 9-0 unanimous decision issued by the Supreme Court involving the Fourth Amendment's protections and exactly when excessive force by law enforcement impacts those fundamental rights. This is a story about a massive legal shift that just took a very strange and unexpected turn. You see, the Fifth Circuit Court has now issued a new ruling that seems to be potentially defying that unanimous decision by the Supreme Court, and this whole battle could be heading right back to the High Court much sooner than anyone expected. It's a critical case, and we need to break down exactly what is happening here. But before we jump into the deep end of this legal drama, if you want to support what we do here, the best way to do that is simply to hit that subscribe button. It really helps us keep these updates coming. Also, I want to mention our supporters at Attorneys on Retainer. When it comes to self-defense protection, they are truly in a league of their own. They've recently expanded their benefits to guarantee 4 attorneys for your specific case, if you ever find yourself in a self-defense situation. It's the kind of protection every gun owner should consider, and you can use the code ARMSCHOLAR to get a significant discount on their plans. Now, as I mentioned, we're looking at a unanimous decision from the Supreme Court in a case called Barnes versus Felix. This case is a direct look at the Fourth Amendment's protections against unreasonable searches and seizures, specifically focusing on how law enforcement uses excessive force. But here's the kicker. Just 6 months after the Supreme Court issued their ruling, the case is already teed up to go back for a re-review. Why? Because the Fifth Circuit just issued a new ruling in light of what the Supreme Court said, and they basically reached the exact same conclusion as before, claiming the officer's actions were protected. The Fifth Circuit has engaged in some very interesting legal gymnastics here, and it has created a situation that demands our attention. Let's look at the facts, because they are tragic and complicated. It started when a law enforcement officer, Roberto Felix Jr., pulled over a man named Ashton Barnes for suspected toll violations in the Houston area. There were reports that the vehicle might have been a rental car as well. Officer Felix ordered Barnes to exit the vehicle. Barnes opened the door and acted like he was going to comply, but then, in a moment of panic, he tried to drive away. He attempted to flee, which we can all agree was a terrible decision. But the situation turned deadly because of how the officer reacted in that split second. Instead of staying back, Officer Felix decided to jump onto the ledge of the car as it was accelerating away. While hanging onto the moving vehicle, he pulled his firearm and fired 2 shots at Ashton Barnes. Both shots hit him, and while Barnes managed to pull the car over, he unfortunately passed away from his injuries. In response to this, Barnes's mother sued Officer Felix, alleging that the use of deadly force was a clear violation of the Fourth Amendment's protection against excessive force. Now, here is where the legal battle lines were drawn. On the first review, the district court granted summary judgment in favor of the police officer. They applied what the Fifth Circuit calls the moment of threat rule. This rule is very narrow. It basically tells judges to only look at the exact millisecond the trigger was pulled. If the officer was in danger at that precise moment, the shooting is justified. Under this old rule, everything that happened before the shooting, like the officer's decision to jump onto a moving car, was considered irrelevant. It couldn't even be discussed in court. This case eventually made its way to the United States Supreme Court, and they were not happy with that narrow view. In a 9-0 unanimous ruling, the Supreme Court held that any claim of excessive force must be analyzed under the Fourth Amendment's objective reasonableness standard. They stated very clearly that the inquiry into whether an officer's force was reasonable requires analyzing the totality of the circumstances. They rejected the moment of threat analysis entirely, most importantly. The Supreme Court said the totality of the circumstances inquiry has no time limit. While the precise time of the shooting matters, earlier facts can show why a reasonable officer would perceive a situation as threatening or harmless. They ordered the lower courts to go back and look at the entire encounter, including the officer's own actions leading up to the shots. After that massive win for the Fourth Amendment, the case was sent back down to the Fifth Circuit for re-review. This is where things get really strange. The panel in the Fifth Circuit didn't hold new oral arguments. They didn't even ask for new briefs from the lawyers. They just took the case back and issued a new ruling on their own. And guess what? They held that even under the new totality of the circumstances approach, the officer's actions were still warranted. Their reasoning was that any vehicle flight creates an automatic deadly threat, and therefore the officer was justified in responding with lethal force. Naturally, Barnes's attorneys were stunned. They immediately petitioned for a full panel review, arguing that this new ruling directly contradicts what the Supreme Court just said. They pointed out that one of the judges, Judge Higginbotham, had previously said that if they were forced to use the totality of the circumstances approach, there was no way they could rule in favor of the officer. Yet here they are, doing exactly that. The petition argues that the Fifth Circuit has essentially created a per se rule that allows officers to shoot any fleeing driver, even during a minor traffic stop. This is a massive conflict with Supreme Court precedent, which has long held that fleeing in a vehicle does not automatically give an officer the right to use deadly force. Despite these heavy arguments, the Fifth Circuit has already denied a full review of the case. They issued a notice of denial saying they aren't going to take it on. So, as of the 21st of this month, a mandate has been issued, effectively closing the case at the Fifth Circuit level. But this isn't the end of the road. Barnes's family now has 90 days to seek review from the Supreme Court once again. This would put them in a position to be back in front of the High Court by early February. It is honestly surprising to see a lower court move so quickly to push back against a unanimous 9-0 ruling. By refusing to ask for new briefs or hold new arguments, it feels like the Fifth Circuit was just trying to find a way to reach the same conclusion they had before, while simply changing the labels they used. They've essentially told the Supreme Court, "We heard you, but we're going to keep doing what we were doing anyway." This sets up a major showdown. If the Supreme Court meant what they said about the Fourth Amendment and the totality of the circumstances, they cannot let this ruling stand. We are going to be watching this incredibly closely. This case is about much more than one traffic stop in Houston. It's about whether the government can ignore the context of an encounter to justify the use of deadly force. It's about whether a 9-0 decision from the highest court in the land actually means anything when it hits the lower courts. The petitioners are making a very strong case that the Fifth Circuit has failed to properly apply the law, and they are ready to ask the Supreme Court to step in and fix it a second time. So that is where we are right now with this critical case. It's a developing story, and as soon as we see the next move from the Supreme Court or the attorneys involved, I will be here to break it all down for you. If you found this update helpful, please do us a favor. Like the video, leave a comment with your thoughts on the Fifth Circuit's move, and make sure you're subscribed so you don't miss the next update. You can also check out one of the other videos here on the screen that the algorithm thinks you'll find interesting. As always, thank you so much for your support. This nation was built by armed scholars, and it will be maintained by armed scholars. We'll see you in the next one.